Okay, so when they come back from break, before the prosecution is already objecting to the defense before he even starts his opening statement because he wants to show pictures. We'll see how the judge handles this.
Proceed to the defense opening. It's my understanding that counsel's going to be showing some videos to the jury.
Okay.
These aren't evidence yet. I don't know what's going to be shown, and I think it's unusual procedure. I've often considered using exhibits in my opening statement, and I think it's generally accepted that they're not evidence yet. So
it's generally accepted. Doesn't say it's a rule. Doesn't say he can't do it. He's just trying to finagle his way, saying, I don't want him showing pictures.
We can't be showing them to the jury unless they're in evidence, and we don't have any of this in evidence yet, so I would object to that.
Well, he does need to tell you what he intends to show. I got to turn things on here. He does need to tell you what he proposes to show, and me too, but the rule does not preclude their use during opening statement.
Good. So he says he does need to tell you, which falls under discovery, but the rules don't prohibit it. So it sounds like he's going to get to show his pictures.
At all. What's up, Mr.
Your Honor, the first slide is a jury instruction, part of self-defense. The second slide is a picture of Joseph Rosenbaum wearing the maroon shirt for identification purposes. The third is a video at the Ultimate Gas of Mr. Rosenbaum having to be restrained. Fourth is a still photograph of Mr. Rosenbaum walking down the street after arming himself with the chain. The fifth is a picture of Joseph Rosenbaum taken from the video at the Ultimate Gas Station of him and Mr. Zeminski. The sixth photograph is once again a picture taken by Nathan DeBrune of Joshua Zeminski and Joseph Rosenbaum starting a fire at the trailer. And in that one, Mr. Rosenbaum is wearing a blue mask. Number 7 is a picture.
These two look like they're related to Kyle. I don't know if this is the family or not, but they kind of look like they're related.
From the Ultimate Gas Station, taken from a video of somebody who's commonly been referred to in this as Yellow Pants Man. Kelly and Joshua Zeminski showing Joshua. Number 3, McGinnis. Number 8 is Gage Groskowitz. Number 10 is a still photograph.
Number 10, you're going to show 10 photos in an opening statement already? Dude, I'm already bored. What happened to this guy's hair? And this guy, what the?
Of Gage Groskowitz running down Sheridan Road. Number 11, 12, as it is in number 11, at the confrontation, and the non-complaining witness photographs taken. 15 is a photograph of he's confronted by Yellow Pants Man and 3 other armed individuals that evening, and those photographs are blown up. In 17, showing one individual, blue shirt, armed. 18 is a video.
Oh my God!
Tried to return photograph. Sure, his medical is the video my client photograph of Mr. Z. 2 is those individuals with 2 circles, one identified. 23 is a video
holy shit
from edge of car source, and that's what Kyle was running to. There's approximately 100 people there, and you hear those people start taking off from car source. 24 is the video where Kyle begins leaving.
This is the opening statement? Jesus Christ, I'm already bored and I'm not even on freaking jury yet.
Car source 3, after the yelling, get Kyle, it's about 5 inches unarmed. Yeah. Photograph 26 is from sleeveless, and then right after that, Mr. Hughes' photograph is a still photograph. One of those shoes, the trucks of the skateboard, gun with his left hand. The next photograph is depicting Jump Kick Man getting up from the ground, having escaped from the right of the frame. And then there's a picture of Kyle Rittenhouse on the ground, individuals approaching him, one with a pipe, one with his hands up. He backs them off, does not fire. 11:51, him, video, trying to turn himself into the Kenosha Police Department at...
I guess we don't need any witnesses. We've got the whole trial there. I thought the opening statement was supposed to be a summary of the evidence, not the evidence itself. This is, I think we're up to 41 videos and photos that are going to be seemingly introduced through the testimony of Attorney Mark Richards. This is a highly unusual procedure, Judge. Both sides will have the opportunity to call witnesses to talk about these things. We will have an opportunity in closing arguments to characterize these things. But to give the jury what the defense considers, and I'm not conceding that these things are all the evidence or even that a lot of these things are relevant, but for the opening statement to essentially be the entire defense case and all the evidence, showing it to them is highly unusual. I took the approach in my opening statement, and I guess I was not pushing the envelope as far as I should have, but it's always been my approach that I will describe...
Oh, quit crying, you freaking pansy.
what I believe the evidence is going to be, but I'm not the witness. I'm not giving them the evidence. That's what the testimony is for. We've had a stipulation as to the authenticity of a lot of the things that counsel's talked about. That does not mean that they're admissible into evidence. It does not mean we're conceding relevance to those things, and I anticipate that there will be some arguments as to the relevance of a lot of these things. We've already had some arguments about some of these things. So, you stressed that it took 5 minutes for him to list all of those things, let alone what it's going to take to actually show them and play them
I would
for the
agree
jury.
with that.
So I think, as a general policy, Your Honor, and I understand it's not necessarily the law, but witnesses should be presenting evidence, not the attorneys in their opening statement. So I object to this procedure. I think it's overly long. It's duplicative of what the evidence is going to be. There'll be an opportunity through witnesses to present all of that. I think counsel should be describing what he thinks the evidence is going to show. That's appropriate. But showing them all the evidence this way, why do we even need witnesses at this point? I'll get up and I'll play all the videos I want to play. They'll play all the videos they want to play, and then we'll just be done without any testimony. That's not the way this trial should work. So I don't think this is a proper procedure.
Man, he's really like slamming the judge if he allows it.
Your Honor, and I do object to it.
Okay. Well, first of all, are you going to be able to authenticate each and every one of these?
All of these come from exhibits that have been agreed or stipulated to their authenticity.
And they're all going to be relevant?
They all are relevant. They've all been.
It sounded like what I've already heard about, by and large. The standard is not what you did or what you can do or could do. The standard is what the law allows, and I can.
I'm liking this judge. He ain't letting the government push him around. I love it.
Remember, studying this 50 years ago, that this was an acceptable way, with judicial permission, to make an opening statement. We see it more in civil cases than in criminal. It's not customary in criminal cases, but I've seen it done by your office. And I have to say that you're right. This is a record number in terms of the numbers. But on the other hand, there's a large number of crimes being charged and separate acts that are being asserted with respect to both the acts that the state alleges were unlawful and the defendant's claim of self-defense. So, given that they do appear all to be relevant and they've been agreed as authentic, then I don't see any reason that I should interfere with his right to make an opening statement. Mr. Springer makes a good point in reinforcing my comment that this is supposed to be brief and informative. So
I
keep
don't
it.
think I'll be any longer than him, Your Honor.
Bless you. All right. Anything else?
Yes, Your Honor. One of the motions in limine I filed, which was not objected to by the defense, is that there be no reference to any pending or prior criminal cases or convictions with regard to Joseph Rosenbaum.
Okay, so this is where the defense always doesn't want the jury to know that I'm holding something on someone's head. I'm holding that this witness is going to go to trial after this, and therefore it will taint his testimony, which it should. The witness is basically his witness. He's calling him with a charge and a trial hanging over his head. Anybody that doesn't believe that he is going to cut this guy some slack if he helps him, or slam him if he hurts him, this makes the witness biased, and the jury should absolutely know. We'll see how the judge rules.
The parties are aware, the jury is not, that there was at the time of his death a pending criminal case between Joseph Rosenbaum and his girlfriend, Carrie Ann Swart, and there was a bond condition that prohibited Mr. Rosenbaum from having contact with her. The purpose of my motion in limine, which, as I said earlier, was not objected to by the defense, was we're not going to talk about that. Now, I made a reference in my opening statement to the fact that Mr. Rosenbaum saw Ms. Swart that night and was not allowed to stay with her, was not able to stay with her that night. And I purposely worded it that way, Your Honor, because there are many reasons why someone may not be able to stay at someone's residence. It could be because of a bond condition. It could be for a myriad of other reasons. It's my understanding from an off-the-record discussion with counsel that he intends to go into this. He believes I've opened the door to it. I wanted a pretrial ruling from the court on this issue. We got one. And I'm now raising it because if it's going to be mentioned in the opening statement, I think this is the time to address this issue rather than in the middle of an opening statement. So I'm bringing it back up again. I do not believe that my statement opened the door to it. And frankly, my statement is not evidence. So I don't know that it can really open the door anyway. But by and large, I was very careful in the way I worded that. And I don't think it opened the door. I don't think, regardless, this is a relevant issue for this trial. Mr. Rosenbaum's conduct with regard to Ms. Swart has nothing to do with what was going on the street that night. So it is completely irrelevant, and I would ask that the court reaffirm its prior ruling on my motion in limine.
Your Honor, he can't have it both ways. He can't go and say he was at the house and he couldn't stay there and not. Why can't we tell the jury why? Because there was a no contact order. It's not appropriate. He thinks he didn't open the door, but he danced through the door. And he also talked about the hospital, got out of the hospital. He was in a mental hospital, and he's going to put her on the witness stand, and we're not going to get to ask that? That's insane.
I was very careful about the word hospital, Your Honor. I believe it was actually St. Luke's in Racine, which is a medical facility. It is not a mental institution. This wasn't Mendota or Winnebago or something along those lines. And frankly, I'm not even 100% certain why he chose to check himself in. But again, whether or not Mr. Rosenbaum needed a new kidney or needed medications for mental illness or was going to have his blood pressure checked has nothing to do with the events of this night. And frankly, it's just a backdoor way of attacking his character and suggesting to this jury that somehow because there's going to be an allegation from the defense that he had some sort of mental illness that had something to do with his behavior that night. Well, I'd love to hear an expert on that, I guess, if they want to try and present that, and we can go down that line and we can talk about whether mental illness contributed to his behavior. What was his diagnosis? What medications were he on? We can open that door and go all the way through it, but that's a mini trial on an irrelevant issue. And if it's going to come in, there's a way to get it in through an other acts motion, which was never filed by the defense. And I certainly have not opened the door when I talk about the word hospital. This could be COVID treatment. It could be a kidney transfer. It could be anything. It does not open.
Could be. Why wouldn't you want the jury to know what it is? Why is a prosecution wanting the jury to be confused about something? But Rick, I thought a trial was to get to the truth. Yeah, that's because you're a dummy. Freaking government.
Again, I was very careful in the way I worded that, Your Honor. If I start talking about his medications, or I start talking about, seeing a psychiatrist or something like that, that's different. Hospital is a very nebulous term that could mean a myriad of things.
Help me out here. I thought when I read the pretrial motions, and I know there were a series of them on which there was agreement, so I probably may not have the best recall of those because I didn't have to put too much thought into it. But I thought that the references or the statements which were attributed to Mr. Rosenbaum were, "I just got out of jail today." You're telling me that there was also a discussion about hospital? No? Or
there's no video or statements or audio of Mr. Rosenbaum talking about the hospital. The only relevance it has, Your Honor.
Well, wait a minute. So
sure.
Is there testimonial? Are we going to hear testimony that he made statements that he had just gotten out of jail that day?
There's going to be statements to that effect.
Okay. In fact, your statement on your opening statement was, and I will tell you this. I'm going to ask you to try to reconstruct from you if necessary. I'll have the reporter read it. But I don't recall the exact statement. I do know that I thought at the time, I'm surprised he's going into this because it may trigger a response. So what exactly did you tell the jury?
What I said, Your Honor, is that Mr. Rosenbaum had gotten out of the hospital that day
Right.
and was carrying around a plastic bag,
Right.
which is the kind of bag that hospitals give you to carry around your personal belongings. The only relevance that has to this case
Well, I
is
don't know.
that's the bag.
I just wanted to get
Sure.
the statement.
Yeah, and I was doing that because
Okay.
the bag comes in, and that's the only
I understand.
relevance.
Okay, now, and you also made a statement about his being with the person by whom he was allegedly bound not to have contact.
That's true.
And do we know the exact scope of that order?
I believe it was a straight, typical,
I don't
no
know
contract.
Typical. No.
We can look it up, Your Honor.
Yeah. Well, what did you say about it? What did you say about it?
What I said is that he had seen her after he got out of the hospital,
Right.
that he couldn't stay with her, and so then he left and essentially came downtown. And Ms. Swart will testify,
Why
and
did
she
you
will
say
talk.
that he couldn't stay with her?
I'm sorry?
Why did you say that he couldn't stay with her?
I said that because it explains why he left and came downtown. He's got a hospital bag, Your Honor. It's a little unusual, I think, for someone to be.
He wants to hide it from the jury. It's obvious why he's doing this. Again, we're not talking about getting to the truth and giving this guy a fair trial. We have Poindexter, pathetic lawyer DA trying to win a case to be a big shot at the expense of an 18-year-old kid's entire life. He is disgusting.
Released from a hospital, have a bag of their personal belongings, go to their girlfriend's place, and then continue to walk around with it. That's a little unusual. We know what was really going on.
And by the way, how do we know that he had been there and had left? Is she going to testify?
Yes.
Okay.
Yeah, and so she's going to talk about seeing him. She's going to talk about that bag, and she's going to say she saw what was in that bag. And this comes into play, Your Honor, because this is the bag that was thrown at the defendant. There's been some allegations out there that this is a Molotov cocktail, or it's got chemicals in it, or it's got something that could cause the defendant harm. It had toothpaste, mouthwash, and a water bottle in it. That's the narrow relevance of this bag.
How did the guy getting something thrown at him know what was in the bag? That's totally irrelevant. What he knows now, for hindsight, what was in the bag, it's what is in the mind of the person that acted, which is Kyle getting something thrown at him at night at an angry mob where shots are being fired and there's chaos everywhere. And he's saying, oh, he threw some toothpaste at him. Dude, you can't move your lips without lying or misdirecting.
Well,
That's why
I'm
the
not
hospital.
concerned. The relevance is not something I want to talk about now. I want to talk about what you said and
Sure.
why he thinks it is worthy of response.
He's misrepresenting the facts of the case to the jury by saying hospital when it was a mental hospital. Mr. Binger knows full well.
Why isn't that a hospital?
He'd gotten out for a suicide attempt.
So?
And
It's a hospital.
and let the jury know what type of hospital it was. Why he was acting the way he was. He was not acting appropriately. That's part of the defense. And,
Boy,
and then he goes and says, can't stay there. Why can't he stay there? Because there's a court order that says he can't. He wasn't supposed to go there in the first part.
And if he was on trial for violating his bond, then we'd have that trial. But he hasn't been tried or convicted of that because he's deceased. But, Your Honor, and by the way, we have the bond.
If he's deceased, then he really has no standing to object on what's being said. That would be my argument. He's got no standing. He's dead.
Condition here. It's no contact, including the residence, electronic or third party, with Carrie Ann Swart and the Park Ridge Inn, which she stays there, and they had been staying there together until that criminal case started. So, if we want to charge Mr. Rosenbaum with violating his bond, what good would it do? He's deceased. But yes, that is true. But again, it doesn't make him a criminal on this evening. It doesn't make his behavior help explain any of that stuff.
I don't think, as far as your opening statement, you need to respond to his statement about the hospital. I'll have to separately decide
Understood.
at a later point as to whether he had.
So far, I think the judge is being pretty kind of critical, both sides, and he's not shutting the door on it. But so far, I'm okay with this judge, even though he likes to talk to the jury a little bit.
Been hospitalized, and for what, I don't know if that's admissible or not. I suspect that it is not, but I'll keep an open mind. As far as his not being there or not supposed to be there, again, I'm not sure that I want to hear about that in your opening statement. Again, I'll hear you later as to why you think that would be relevant.
Because he's talking about my client traveling here from out of bounds,
Right.
and he's trying to say, oh, he had a good excuse for not being at home. He couldn't stay there that night. Well, jury should know why he couldn't stay there.
Well, I don't know. If he can't stay there, can't stay there. She could have kicked him out because she didn't like his having a hospital bag. I don't know. I'm not sure it's necessarily relevant. He was where he, like the defendant, was not supposed to be, allegedly. And
See, now the judge made his ruling, and sometimes arguing with his ruling doesn't really help you. I mean, he's not going to change the judge's mind right now. The judge gave you a way to get it in later. Take that and move on. You don't want to fight every battle with the judge, and then the judge gets tired of hearing you because he thinks you're just going to fight everything. So I don't know if he should push this issue.
let it play out, but don't talk about those two things in your opening statement. Anything else?
No.
Okay. Would you come down, please? Okay.
If the jury's coming in, why isn't Kyle standing? They should tell him to stand. Oh, okay. I guess too early. Oh, did he just yawn? See this nervousness? This is a nervous yawn, people. Everybody's making a point of this. Somebody should tell his attorneys, look, and you need to clear this up for the jury. You don't want a jury thinking like these dumbass attorneys on freaking court TV saying he's yawning because he doesn't care. That's not while he's yawning. Not to mention he probably gets no sleep. He's fighting for his life, and this is the first day of trial.
When you're dealing with, what do we got? 5, 6 lawyers in the room? What do you expect? All right, let's go, Mr. Richards.
This is my opportunity to tell you and show you what I believe the evidence will show. You've heard the state's opening statement, and now I will give mine. We have two very different outlooks on the events of August 25th of 2020. Kyle Rittenhouse was present in Kenosha, Wisconsin on the evening of August 24th. He stayed at his friend's residence, Dominic Black. He saw on the live streams and things like that the events of the 24th. He saw car source number 1, as I refer to it, the one that's on the east side of Sheridan Road. He saw the other businesses burnt down. And the next morning he went down to downtown Kenosha to look at the damage. He stopped and he helped clean up at the old Ruther High School. I think it's called something else now, but when I was around here it was called Ruther, and before that Bradford. And he saw that. He met one of the owners from CarSource and they talked, and they decided that they would offer their services, him and Dominic Black and Nick Smith, to help protect the property of CarSource. Ladies and gentlemen, the evidence will show, in spite of what the media and public statements and things like that have been, the evidence will show that Kyle Rittenhouse had strong ties to Kenosha. His father lived in Kenosha. His mother lived in Antioch, Illinois. Kyle worked here in Kenosha County at the Recplex in Pleasant Prairie as a lifeguard.
That's a good point. Making that it doesn't look like he just came over here looking for trouble. He had a lot of ties. He was here a lot.
He went downtown to clean up the graffiti. Him and Nick left there, and they decided to come back that evening and help CarSource Lot 2, which is at 59th and Sheridan, and initially CarSource 3 at 60th and Sheridan. And when they were doing that, they met other individuals who had come to town at the urging of websites and things like that, and then just a general, I would say, distaste for the destruction. And those guys from the West Bend area, Ryan Balch, Lukowski, joined. They went to the lot at 59th early in the evening in video and still photographs like that. It was Kyle Rittenhouse's actions privileged under the law of self-defense. That is, that the defendant believed that there was an actual or imminent unlawful interference with his person. The defendant believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and that his belief was...
We're 2021 and you can't get a lapel mic for a freaking attorney. You can pay $4,000 for a freaking toilet seat. We can give illegals coming across the border millions of dollars in free health care, and we can't get a freaking lapel mic for a defense attorney? Come on, dude.
Reasonable. You as jurors will end up looking at it from the standpoint of a 17-year-old under the circumstances as they existed on August 25th of 2020. And Mr. Binger makes a big thing out of Kyle Rittenhouse was the only person who shot somebody that evening. True. Mr. Rittenhouse was the only person who was chased by Joseph Rosenbaum that evening. This is Joseph Rosenbaum. And what's important in this photograph is, one, it will allow you to identify him throughout the course of trial. Notice the belt, the baggy, lengthy jeans, and there will be a fair amount of testimony, I'm sure, regarding the maroon shirt. He's obviously currently wearing it. Mr. Rosenbaum was at a location, and Mr. Rosenbaum had, along with other individuals, started a dumpster on fire. And when somebody put that dumpster that was very close to a gas station out, Mr. Rosenbaum became enraged. I'm going to go back. Does this sound on? That's just a brief snippet of that interaction. And he was upset, and he's yelling that he wants to be shot. And you'll see individuals in the full video, which you'll see in the course of trial, holding him back, trying to stop him from getting at an individual who is dressed with a baseball cap, an AR rifle, and short pants, who looks very much like Kyle Rittenhouse. Here's Mr. Rosenbaum during the evening. Him and his friend or associate, Joshua Zeminski, had just come from starting a trailer on fire. He arms himself with a chain and goes up and down Sheridan Road, carrying this rather heavy chain used to tie down equipment. Next is a still photograph taken from the Ultimate gas station where he was shouting, "Shoot me, nigger," at a Black Lives rally. Who is that behind him? Joshua Zeminski. The evidence will show that Mr. Zeminski, also named as Alec Blaine, and Mr. Rosenbaum are together throughout the evening. And Joshua Zeminski plays a central role in this scenario on August 25th. One, creating chaos and havoc with Mr. Rosenbaum. And two, more importantly, when we finally get to car source number 3, Mr. Zeminski is the individual who fires the first shot that evening, behind Kyle Rittenhouse as he's being chased by Mr. Rosenbaum. Here's a picture with 2 circles. Mr. Rosenbaum and Mr. Zeminski starting the trailer on fire on Sheridan Road along with a dumpster. You see the photograph, the second one circled. Testimony will show that that is in fact Mr. Rosenbaum wearing a blue mask, not his shirt over his head, and carrying a bag, which I'm sure there will be much testimony about. Other individuals in this, once again, Mr. Zeminski. In the photograph taken at the Ultimate, this is a still from one of the videos you'll get to see, is Mr. Zeminski armed with the weapon that he ultimately fires at the car source 3. The individual with the red hair is Kelly Zeminski. She has a backpack, and there's a circle on her hand with a big, heavy flashlight. As you can see, there was no need that evening for a flashlight other than it being a weapon. Count 2 is an individual by the name of Richard McGinnis. He was a reporter covering the riots in Kenosha. He had covered the riots in Portland, Minneapolis, and he will tell you, what he's called to the witness stand by either the state or myself, that he was dressed like this that night. The black t-shirt with the white back. Rittenhouse were going to go out and see if anybody needed medical attention that evening, and Richie McGinnis was going to follow along. Eventually they have an interaction with the individual who we were victim, or excuse me, the complaining witness in count 5. I apologize. Throughout the evening, filming. Photograph 10, the next photograph, is, the evidence will show Gage Groskowitz running down Sheridan Road to arm himself. The evidence will show, through testimony of an individual by the name of Nathan DeBrune, that yellow dot right up there is where Kyle Rittenhouse is as they chase him down Sheridan Road. Mr. Groskowitz is not in any danger. Kyle Rittenhouse has already told him that he's going to turn himself into the police, yet he arms and continues with the mob to attack. Laying on the ground after being kicked in the down Sheridan Road, and then as he's laying prone on the ground, he comes in for another hit on his head, and then grabs Kyle Rittenhouse's firearm to try and take it away from him. The next photograph is a picture.
See, I think he should have slowed in there. Anyone, any reasonable person in this situation where people are in a mob and trying to take your gun, it's just reasonable that you would be in fear of your life and would know that if they got your gun, they're probably going to kill you or beat you to death. Your gun is your only way to stay alive. That is a reasonable point of view. Well, she could have got that in there.
To look at the whole skateboard, the size of that skateboard, the trucks of that skateboard. Ladies and gentlemen, I would love to be able to hold up that skateboard in front of you as evidence today, because then you could see it. You could see the weight and the heft of what a skateboard is. And what that skateboard would do is somebody takes it in their hand and swings down on somebody's shoulder, head, and neck, trying to separate the head from the body, as Mr. Huber did. But
Your Honor, I'm going to object to the argument here, Your Honor. This is straying beyond a characterization of the evidence, and it's Mr. Richards' interpretation as an argument.
So normally you don't object during openings. It's kind of like one of those things. He objected before his opening, and now he's objecting. What he's going to try to do is try to win on little legal bullshit things and try to score points with the jury. Hopefully the jury will get pissed off at him and say, just shut the fuck up and let him finish if he keeps doing it.
you'll see the photographs, you'll see the videos, and ultimately you'll get to make the decision of what Anthony Huber was trying to do. The skateboard doesn't exist because Ms. Giddings, his girlfriend, in spite of repeated requests by Detective Howard, refused to produce it. That's what the evidence will show. Mr. Huber, at the Ultimate Gas.
Wow, I can't believe they didn't get the skateboard. How can you not get the skateboard? You do a freaking warrant, you go search. If she has a skateboard, admitted having a skateboard, you arrest her and hold her in contempt. You get a court order and say, give up the skateboard or I'll put you in jail in contempt and you'll stay there till we get it. How can you not get that skateboard? I'm shocked.
Holding back Mr. Rosenbaum, who is ultimately the individual who lit the fuse that night. Man I refer to as jump kick man or the non-complaint.
If I was working for the defense, I would contact that lady with the skateboard, not let them know I'm working for defense, and say, hey man, I want to sell that skateboard on eBay after this trial. I don't know how much I'll get for it, but I'll give you $500 for it if you give it to me. And then after the trial, I want to sell it. And money talks. She would sell me the skateboard and I'd give it to defense, and then we'd give it to the freaking prosecution because their dumbass couldn't get it.
Complaining witness. Kyle is laying on the ground after being knocked to the ground by an individual hitting him in the head with a rock. Anthony Huber hitting him with the skateboard. And Jump Kick Man comes in, kicks him square in the face with his black boot. Close-ups of that. And as he's kicking him in the face, Kyle fires.
Anytime you can show the jury pictures that help you, kind of like they did in George Floyd, they showed that picture of him on the ground with a knee must have been showed 1,000 times. That's what you want to ingrain in the jury. So him getting these pictures in at the jump street, and then he's going to show them during the trial, and then he'll show them again in the closing. That's good technique, I think.
Fires 2 shots at that individual. He's not hit. He gets up and he runs away into the night, never to be seen again, never coming forward to identify himself as a victim, complaining witness or otherwise to law enforcement. We look for him, the evidence will show. The state looked for him, the evidence will show. Those are the big players in this case. But ultimately, what you'll end up having to decide, looking at all the circumstances of that evening, are the events that occurred over really a brief 15-minute period, but more importantly, 3 minutes. The police spread or push people south to approximately 60th. That's something we can agree. There's no line set up to stop Kyle or anybody else going in a southerly direction down Sheridan Road. There's no statement that if you go in that direction, you can't come back if you have business in that direction. Kyle, an individual by the name of Ryan Balch, followed by Richard McGinnis, go down there, Sheridan Road. And at 11:40, they have a conversation yelling medic. And you'll see the videotape of this event. Kyle's got his medical bag, his gun, and he comes upon these 3 individuals. And the individual in the yellow pants.
Something else I think that he should get out somehow in trial is that having a medical bag in a right situation like that is sometimes makes you a target of drug users or drug abusers or people that need a fix. In your medical bag, they may think that you have chemicals or pills in there that they could use, and the likelihood of you getting attacked for them to try and take that is higher which is why being armed is probably smart and prudent. I'd probably try and get that in there.
Accuses Kyle Rittenhouse of pointing a laser sight from a gun at him. Kyle shrugs it off, does not want confrontation with these individuals, does not point his firearm at him, and he leaves. Why does he leave? Because he doesn't want trouble.
Since he didn't say he didn't even have a laser, I'm assuming he had a laser on his gun. I don't know. If he doesn't have a laser, this would have been a point to say, Kyle doesn't even have a laser on his gun. So we know Kyle didn't do that. But since he didn't say that, maybe he has a laser on his gun.
These are the three individuals who were with Yellow Pants. One individual is carrying a noose. I don't know what that's for. The other individual, the testimony will be from Kyle Rittenhouse and Richie McGinnis, had rocks in his hands. And then the blue-shirted individual was carrying a 9mm firearm. Richard McGinnis will tell you about the marauding nature of these individuals. He was so intimidated by them after Kyle walked away that he had to give up 2 White Claws to him to settle him down and some cigarettes so that he would be able to leave them. Kyle, from there, realizes he's been separated from Mr. Balch. He goes over to the Ultimate gas station looking for Mr. Balch and is unable to find him. What happens next is he attempts to get back to Car Source at 59th and Sheridan Road.
Since we can't see this, I'm just going to bump past it.
That they're breaking windows and starting fire, and ask the individual to go down to Car Source 3 with him. To Car Source 3. He heads down Sheridan from 60th. Of him from a video, in his other hand, a fire extinguisher to put out the fires that are being started down there. This is an aerial photograph that the state had referred to in its opening. Lettering. It starts very slow.
Okay, we get the gist of his opening. I'm at 31 minutes. We're going to start next on the first witness by the prosecution. Remember, the prosecution always gets to put their case first. They get the first bite of the apple. They get to get the jury bought into their side first. Then the defense has to play catch up and come back. So we're going to hear from the first defense witness when we come back. I'm assuming. I don't know. We'll see.